Hello and welcome to Compliance Briefs on Money Laundering. In this video, we cover a comprehensive overview of money laundering, beginning with a clear definition of what money laundering is. We then delve into the 3 stages of money laundering. The video also outlines various money laundering offenses, including specific acts that constitute illegal behavior. We discuss the concept of tipping off, highlighting the legal implications of prematurely disclosing information on investigations. Additionally, we review the severe penalties associated with money laundering, including criminal and administrative fines, as well as the available defenses that individuals or entities may employ. Lastly, we examine other related offenses and the regulatory framework that enforces compliance, ensuring viewers understand the full scope of money laundering laws and the importance of adhering to them. What exactly is money laundering? It can be defined as any act or attempted act to conceal or disguise the identity of illegally obtained proceeds, making them appear to have originated from legitimate sources. The process of money laundering typically involves 3 stages to release laundered funds into the legal financial system. These stages are: placement, introducing illicit funds into the financial system. For example, depositing cash in bank accounts in small notes or purchasing high-value assets such as jewelry. Layering, creating multiple, complex layers of financial transactions to obscure the audit trail and provide anonymity, thereby distancing the proceeds from their illegal source. For example, move funds through multiple bank accounts and setting up fictitious shell companies. Integration, reintroducing the now laundered funds into the financial system as legitimate proceeds. For example, selling real estate and claiming a high profit or inflating invoices. It's important to note that not all money laundering cases follow this 3-stage process strictly. The stages may be combined or repeated multiple times. The law outlines the laundering offenses for any person who knows or ought to have known that any kind of property constitutes proceeds from the commission of illegal activities and carries out any of the following activities: converts or transfers or removes such property, acquires, possesses or uses such property, conceals or disguises any relevant information to such property, assists another person to convert or transfer or remove such property or evade the legal consequences of his actions, participates in, cooperates, conspires to commit, or attempts to commit and provides counseling or advice for the commission of any of the offenses referred to above. Discloses information in relation to investigations carried out for laundering offenses to suspects or others, distorting the investigation process. Commonly known as tipping off. As mentioned in the previous slide, tipping off constitutes a laundering offense. No obliged entity, director, or employee of this entity should share any information with the client or a third party that could obstruct or hinder ongoing investigations or inquiries. This prohibition includes any details regarding suspicious transactions that have been, or will be, reported to MOCAs. However, if a member of ICPAC, in the course of their professional duties, advises a client to avoid illegal activities, this does not constitute a disclosure of information under this section. Violating the tipping off provisions is a criminal offence, punishable by up to 2 years in prison and/or a fine of €50,000. Laundering offences are punishable by 14 years imprisonment, and/or a penalty of up to €500,000 where a person knows of a money laundering offence, and by 5 years imprisonment, and/or penalty of up to €50,000 where a person ought to have known. In criminal proceedings against an individual for assisting another person in committing a money laundering offence or terrorist financing, it is a valid defence if the individual intended to report their suspicion about the activity or transaction to MOCAs but failed to do so due to reasonable grounds. It is important to note that any such report should not be considered a violation of any contractual restrictions on the disclosure of information. For employees of obliged entities, the law acknowledges that reporting to the compliance officer, in accordance with established internal procedures, is equivalent to reporting directly to MOCAs. Under the category of other offences, it's important to note that any person, including ICPAC members, who, in the course of their trade, profession, business, or employment, acquires knowledge or has reasonable suspicion that another person is engaged in money laundering or financing of terrorism, is required to disclose this information to MOCAs. If this information is not disclosed as soon as it is reasonably practical after coming to their attention, it constitutes an offence. Failure to report is punishable on conviction by a maximum 2 years imprisonment and/or a fine not exceeding €5,000. ICPAC may impose and publish administrative fines of up to €1 million on any member who fails to comply with the requirements of the law. If the benefit gained from the breach exceeds €1 million, the fine may be increased to twice the amount of the derived benefit. Should the offence continue, an additional daily fine of up to €1,000 will be imposed for each day the violation persists. Moreover, any ICPAC member who fails to meet the legal requirements may be referred to the Institute's Administrative Sanctions Committee for disciplinary action. This could lead to amendments, suspension, or withdrawal of the member's license, and potentially a temporary ban. This process applies regardless of whether money laundering or terrorist financing has occurred. I hope you found this useful. For any queries, you may contact us via email at compliance@icpac.org.cy. Thank you and goodbye.